ಅದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇರೋದು. AGO. No, my regular court only. I'm only appeal police notes. ನೀವು ಆಕ್ಚುಲಿ ಬೇರೆ ರೆಸ್ಪಾನ್ಸ್ ಬರಬೇಕಾಗಿತ್ತು. Because here, this was the proceedings to post the litigation and responding number 5 and number. So you have to be present.
Hello. Hello. Voice button.
You want copy to SPP office?
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್ ಕರೆಕ್ಟ್ ಮೇಡಮ್ ಎಸ್ ಪಿ ಪಿ ಮೇಡಮ್ ASPP ನೋ ಪ್ರಾಬ್ಲಮ್ ಇರ್ಲಿ ಬಿಡಿ ಅವರು
ಇಲ್ಲ ಬಿಡಿ I'll take notice. They just told to take notice. ನಿಮ್ದೇನಿಲ್ಲ GM
What is the issue?
No issue is for further investigation. It's a regular art subject. Because
Further investigation is directed to?
No, not further investigation. They are seeking for seizure of mails and books. ಅದು ನಿಮ್ಗೆ ಬೇಕಾಗಿಲ್ಲ ನಮ್ದೇ ಸರ್ ರೋಸ್ಟರ್ ನನಗೆ ಅಲಾಟ್ ಆಗಿದೆ. He got confused. So we have intimated, not required. We spoke to Jagdish sir also.
SPP intimated me to appear.
ಅಲ್ಲಲ್ಲ ಅದನ್ನೇ ಅವ್ರಿಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಸರ್ ಗೊತ್ತಿರ್ಲಿಲ್ಲ. We have clarified.
ಎಲ್ಲರೂ ಬರೀ ಗೊತ್ತಿಲ್ಲ AG ಆಫೀಸ್ ಅಂದ್ರೆ ನೋಡೋಣ SPP ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ ಆರಾಮಾಗಿದೆ ಸಾಹೇಬರಿಗೆ ನಮ್ಮ ಕಡೆಯಿಂದ ವಾಟರ್
ನಮಗೆ ರೋಸ್ಟರ್ SPP
ಸಾಹೇಬರು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಓದ್ತಾರಲ್ಲ ಎಲ್ಲಿ ಓದ್ತಾರ BNS issues in more.
That is how we have to do. ಇಲ್ಲಾಂದ್ರೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಬರ್ತಾರೆ. ಎಷ್ಟೋ ಬರ್ತಾ ಇದೆ ನೋಟಿಸ್ ಚಾಲೆಂಜ್. ಫಾಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ರು ಮೊನ್ನೆ ಫಾಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ರು. ನಾನು ಹೋಗಿ ಅದು ಫಾಸ್ಟ್ ಇದೇ ಥರ ಕೊಡಿ ಯಾರಿಗಾದ್ರು. ದಟ್ ಇಸ್ ದ ಪ್ರೊಸೀಜರ್. ಇಲ್ಲಾಂದ್ರೆ ಆ ಟೆಕ್ನಿಕ್ಯಾಲಿಟಿ ಬರ್ತಾರೆ.
Apologies for troubling your lordship.
Apologize, my lords.
Huh?
Apologize, my lords.
No, that's all right, but
Lords, may kindly allow me to point out some more.
heavens would have fallen.
Apologies, my lords. I'll just
Tell me,
point out.
that's all right, tell me.
No, your lordship, the other respondents have not been served, I think so, because they are the one who have to answer. The
Which
prayer is,
respondents?
respondent number 5
Lords, I'll
is the
restrict-
RP.
I'll restrict my relief only to the state, my lords. Lords, may kindly allow
No,
me
to
to.
the state also, it is only, we are not aware.
Lords,
ಆಯ್ತು
may-
ಹೇಳಿ ಹಾಲಿಡೇಯಿಂದ ಕರೆಸಿದ್ದಾರೆ ಹೇಳಿ
ಆಯ್ತು, ಆಯ್ತು.
ಹಾ.
Lords, may allow me to really.
Who is the one on the BC?
Please, my lords, I'm counsel, my lords, for respondent number 9. We have just checked the e-codes, my lords, and we've seen that there has been something which has been filed. And this, my
No,
lords, is,
even I am not aware. He has.
we have no idea, my lords, what
The
is.
Honorable Chief Justice.
My lords.
All right, tell me what is it?
Lords, may kindly allow me to present.
Yes, yes, tell me.
Lords, I represent the founding director of Think and Learn Private Limited.
What?
Think and Learn. Private Limited, which
Think and Learn is.
is Byju's, my lords.
Byju's,
2015,
yes.
an application called Byju's was created, my lords.
All right,
Now, admittedly, the matter is presently under CIRP, my lords.
correct.
Now, there is some amount of fraud which has happened.
You are representing Think and Learn.
I'm representing Byju's, my lords, because Think and Learn
Byju's.
the CIRP is concerned, my lords.
All right.
An FIR was registered, my lords.
Hmm.
An FIR is pending before the High Grounds Police Station.
All right.
Now, in the meantime, the previous EOC meeting, my lords, if your lords may kindly come to page 63, my lords.
Hmm.
My lords, we do not have a copy of this petition, my lords. They have not given us anything, and Mr.
No,
Honda.
don't worry. If I'm passing any order, I'm going to hear you on that fixed date or whatever it is. But
Great.
what is the impending urgency
I'll
today?
just point out. Page number 63.
I think, tell me, yes.
Page number 63 is the minutes of the previous EOC meetings, my lords.
Previous COC dated
8th of April, my lords.
8th of April,
My lords.
day before yesterday.
My lords.
All right.
The second paragraph, my lords. The RP
Hmm.
further appraised all the members that upon conducting a check on the process ID, it emerges that a total 2,392 emails
All right.
were deleted from the process ID. And upon being asked, the erstwhile IRP stated that these are all on account of rearrangement of folders.
Hmm.
The RP emphasized that the above issue would require further IT examination, and the RP is in the process of analyzing the issue.
Hmm.
Lords, my limited relief for my lords is, my lords, the present RP is a partner of Ernst & Young,
Hmm.
which is a
No, one petition had come before me,
my lords,
day before yesterday,
my lords,
because you said Think and
my
Learn.
lords, my lords,
Think and Learn was the first respondent there.
my lords, my lords,
It was filed by someone else where 27/3/2025,
my lords.
an order was passed by the NCLT
Correct.
where they got, at the time of getting up, they have granted an interim order without hearing. So
Yes.
I have set it aside and sent it back.
My lords,
That I think is on 30th April 2025.
my lords.
In the interregnum, why this petition?
My lords, I'm not representing the party who had approached your lords on the previous occasion, my lords.
Hmm.
I'm representing the founding director, who is a suspended director, my lords.
Hmm.
Now, the present RP is a partner of.
Now you are restricting your prayer to what? You come
Lords,
to your
my
prayers.
lords, we are only seeking.
Your prayer is an amalgam of two jurisdictions. One is GM and one is 482. Hmm.
My lords, may I read, my lords?
You tell me, come to page 53.
Direct respond number 1 to seize the
ನಿಮ್ಮ ಹತ್ರ
corporate.
ಯಾರ ಕಾಪಿ ಇಲ್ವಾ ಯಾರ ಹತ್ರನು?
Nankali ಇದೆ. No, I have.
ಅಲ್ಲಿ ಎಸ್ ಕರೆಕ್ಟ್ ಬಿಕಾಸ್ ಕ್ರೈಮ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಐ ಥಾಟ್ ಸಂಬಡಿ ಫ್ರಮ್
No, no, no,
ಎಸ್ ಪಿ
that
ಆಫೀಸ್
I'll take notice on. I'll take notice for this.
ಹಾ
And I've taken instructions also.
ವೇಟ್ ದೆನ್ ಎಸ್
My lords, direct the respond number 1, that is a investigating officer, my lords,
Hmm.
to seize the CIRP email of Think and Learn, that is ip.byju's, and preserve the same without any further loss of email or data, my lords, in view of the minutes of the COC meeting held on 8th of April 2025, my lords.
Now this is the prayer that you are restricting your prayer to what? Which one?
My lords, if the data can be protected, my lords, if they can at least keep a backup copy of the data,
That the investigating officer will do.
my lords.
So your lordship, what has happened here, these accused, that is accused number 1, 2 and 3, they have
What?
obtained a stay of investigation.
Oh, already a stay is there.
Stay there. So now he is the new RP who's come and we are not aware of it. At least they should have given us a
Which is,
representation.
in which writ petition is the stay?
Repetition
petition?
number
3717, my lords.
3717 of 25.
My lords, may
Have
kindly.
you so said in the petition?
Yes, my lords.
They have mentioned it.
3717.
Four eighty-two.
ಅದೇ 482 ಇಲ್ಲಿ ಅರ್ಧ ಪ್ರೇಯರ್ 482 ಇದೆ.
ಅದೇ.
Well, at page 20 it's mentioned. Lords, may kindly allow me to give a slight background about the case.
You make your submissions.
Lords,
What will pass will pass.
what exactly happened with
I'll
us?
hear you, Rahul.
Right.
Yes.
Lords, may kindly give me 5 minutes. Now, Think and Learn was the official sponsor of Indian cricket team, and in 2019 an agreement was entered with BCCI Lords of 158 crores for the Indian cricket team. In 2021, they had gone to the US Lords, and they had Think and Learn, Think and Learn had gone to US, and they had taken a loan of $1.2 billion through its subsidiary in US. And the Indian entity Think and Learn was a guarantor for the agreement. It was under credit and guarantee agreement. And the agent under the agreement was an entity called Glass. Glass was supposed to represent all the lenders in the US. Now, what had happened is this loan was supposed to be serviced by the end of November 2026. Sometime in April 2023, they said the entire loan had to be paid up, and they issued a default notice. At this point of time, Lords, there was no financial default, admittedly, insofar as the loan was concerned. They had alleged certain default, saying there's a breach of condition or terms. So that particular acceleration of the loan is presently under challenge before the US courts. Similarly, Lords, under the agreement, there was a specific condition which said that any lenders, who are vulture lenders, competitors, and all, are not supposed to invest in the company for more than a particular threshold. So the people who had invested beyond that threshold, that is 5%, all of them got disqualified. So we had as Think and Learn issued disqualification notices to all the lenders. Based on the disqualification notice, almost all the lenders had accepted the same and moved from the credit agreement. It was only one entity called Redwood which had challenged it, and which is also pending before the US court. Now, in the meantime, BCC had approached the National Company Law Tribunal under the Insolvency and Bankruptcy Code as an operational creditor. Notice was issued, but moratorium was not imposed. In the meantime, Glass filed a Section 7 as a financial creditor, alleging that I have a claim as a guarantor in US. They filed a Section 7, and in the Section 7, they were not able to prove that they had the authority to represent the lenders. So they kept it pending. In the meantime, on 16th of July 2024, moratorium was imposed in the IRP proceedings initiated by BCCI.
All right.
Mr. Pankaj Srivastava, who is accused number 1, was made the IRP in the proceedings. Now, it so turns out that the entire CRP proceedings was completely torpedoed by Ernst & Young and this entity called Glass. What had happened is Glass, in its petition, which was filed in January 2024, had specifically named Dinkar Venkata Subramaniam, who was a partner of Ernst & Young, as the IRP. Similarly, as soon as the person, this Pankaj Srivastava, takes charge, he brings in Ernst & Young into the fray as an insolvency professional entity. Now, this happens on the very same day, on 16th. And virtually the entire CIRP is taken over by Ernst & Young on behalf of Glass. It has also come on record that Ernst & Young was advising Glass in this very proceedings insofar as the US debt was concerned. In the meantime, my brother, Mr. Riju Ravindran, had settled the entire claim with BCCI. And that was on 30th of July 2024. And the matter was completely closed by NCLAT by way of an order dated 2nd of August 2024. Now, the matter went to Supreme Court, and when the matter was pending before the Supreme Court, this Mr. Pankaj Srivastava constitutes a COC with this
RP.
Yes,
that is Think and Learn.
Yes. So he constitutes a COC with Glass as 99.41% voting rights. Now, this happens. Now, subsequently, there were certain whistleblower emails from ENY, which has revealed that it was essentially EY which was controlling this email ID, which we are seeking control of, that is ip.byju's, and acting on behalf of Pankaj Srivastava. Now, the interesting part is Pankaj Srivastava was asked to be investigated by the IBBI under disciplinary proceedings by way of an order dated 29th of January 2024. Now, in pursuant to this order, he files an affidavit before the IBBI admitting that he was completely influenced. He had acted at the behest of EY, and he was also being pressurized by Glass. Dr. May kindly allow me to read that portion, Milords. This is at page 199. This is the document which is filed before the IBBI, Milords. My lords, for your lordship benefit, I made a chart also. If this cross-reference page number is available in this. Because the font is slightly small, my lords. Jaldi.
Where is the RP admitted?
It is before the IBBI, my lords.
Where is that? Which page?
Page 199, my lords. There are multiple places. If your lordship may kindly permit me to read page 199, I'll be obliged, my lords.
Just take me to that particular page.
Page 199, my lords. 16/7/2024, my lords. Lordship have it, my lords. It's a landscape.
Yes, I have.
Can I read, my lords?
Yes.
16/7. This is the phase 1 of CIRP, July 16th to August 2nd, 2024. 16/7. Since the CIRP of the corporate debtor is a complex and resource-seeking assignment, the undersigned was necessitated to appoint a process advisor and support team for a smooth transition of the CIRP, Messrs. Think and Learn. The undersigned on 16/7 received a call from Mr. Avinash Balakrishnan of Ketan and Company, congratulating the undersigned for his new assignment and also about the manner in which the claim of glass trust shall be treated in the CIRP process on the grounds that they are claiming as authorized representative of the group of lenders. The undersigned, since did not have any knowledge about any claim, the undersigned expressed his inability to make any comments over the same. Persistent calls had started coming from Mr. Avinash Balakrishnan and Mr. Ashwin Bishnoi, also from so and so, and they stated that whereas they represent Glass as their counsels, they would be able to guide the undersigned in selection of professionals who would be able to support the undersigned for the smooth of the CIP process in efficient manner. The underlined, this should be undersigned, I believe, that the undersigned should engage EY as the process advisor for the CIP of Messrs. Think and Learn. When the undersigned expressed reluctance over the same for the reason that PricewaterhouseCoopers was already providing similar assistance to the undersigned IRP in another large case of Katera India Private Limited, and also submitted their proposal to assist in this matter. Mr. Avinash Balakrishnan and Mr. Avinash Bishnoi of so and so did not favor the same and insisted going with EY as IPE, else my ability to continue in the profession shall get compromised. They further insisted, if I did not cooperate for appointing EY as IPE, they shall malign my image as an insolvency professional, a prophecy that appears, a prophecy that appears was premeditated as things progress.
I don't think you'll have to read all that. Come to page 202.
In the background,
no, that's in the back. In the undersigned was misled. That's enough. By the team, page 202.
Milas.
Non-filing withdrawal application before the BCCI was upon insistence of so and so.
Milas.
And then the RP counsel backtype. It's further pertinent. Abhishek so presently during CRP process was the counsel of so partner and presently appointed resolution professional. Yes.
Milas, we are concerned with the fact that Milas, the entire CIP proceedings was completely taken over by EY on behalf of Glass. And EY was the person who was electively selected Glass as a COC member. And now presently COC is being run by Glass, and Glass has now again nominated another partner of EY, Mr. Shailendra Ajapera, and now he is in charge of IP.Byju's, Milots. Now this IP.Byju's has the entire evidence insofar as this fraud is concerned, Milots. Now if he is in charge, then Milots, we believe the evidence might get lost, Milots, and he's already indicated a lot of emails have been lost, Milots.
Yes. Holla sir is there?
Yes, my lord, I'm here. If they are making, my lord, Glass and making allegations against the Glass, my lord, I would like to, my lord, take a copy and then, my lord, respond to it, my lord.
No, we can respond to it. Now, for now, I will only direct the investigating officer to keep everything intact. That's all.
No, but it is not in our custody.
Whose custody is it?
It is with respondent number 5.
With EY, which is an accused, Milots.
No.
Respondent number 5 is the RP.
No.
Present RP.
No, the present RP.
He should answer.
Nothing is in your custody still?
No, nothing is in our custody. In our custody is only we have taken a statement of this accused number 1, Pankaj, and then the proceedings are stayed before this honorable court. We don't have any material at all.
So stay all proceedings and decisions of COC that you can't seek here.
Milots, I'm restricting only to protecting the data, Milots.
You see, whatever of the COC you have said that can't be agitated here, you'll have to go before the NCLAT.
Understood, Milots.
Because the Apex court recently has held, the IBC is a complete court, so you'll have to go there.
Understood.
Now, insofar as this investigation is concerned in the crime number 44 of 2025.
That is stayed, my lord, by the. There is already an interim order.
That's what, there is already an interim order of stay. Then what investigation do you expect?
My lords, the interim order is not against glass, my lords.
I know, respondent number 5 to refrain from further
My lord, we are
appointing
filing, my lord,
third party
against glass, my lord,
expert.
we did not.
My lords, may kindly allow me to.
Yes,
My lords, ultimately, my lords, the entire evidence rests with his email ID, my lords.
Correct.
And the server, my lords.
Hmm.
Now, we had filed a FIR, my lords. It was filed more than 46, 47 days back, my lords. The police has not even issued notice insofar
No,
as
if there is a stay, what will police do?
stay came much later, my lords. And insofar as the investigation is concerned, nothing has moved forward. At
Yes,
least,
Rahul, who has, you
Malad,
have
may I
the,
also just
No, I
clarify,
have the
Malad, that
papers.
he's
No,
not the
I have the
complainant.
papers, your lordship.
wait 1 minute, sir, 1
I have
minute.
the
I'll get
paper.
back to you, wait.
It's only the statement which we have recorded.
When,
And since there was investigation, that is immediately after the complaint was registered. And then we had asked him to produce further documents, and then he sought for stay of the investigation. We couldn't call him for investigation.
so it's only initial statement.
Only initial statement, stay.
some protection may be given insofar as
How?
the data.
And now,
How? You tell me how.
and respondent number 5, he has to answer.
No, true, respondent number 5, if, who's respond, Holla sir, ತಾವ್ಯಾರು
The
appear
RP.
ಆಗ್ತಿರೋದು?
My lord, I appear, my lord, for glass trust.
That is respondent number 9.
If they give me, my lord, copies,
Or respondent
I
number
don't know, my
9.
lord. They have not even served a copy
Respondent
on
number
us.
5 is now
We
the
only
present
came to know
RP.
of it
He
from
is
my
also a
lord,
partner of EY, my lords.
sorry.
And EY has been hand in glove with glass. Lords, may
No,
kindly.
that is an allegation that you'll have to make it before a separate forum
But-
and Holla sir will answer all that.
Lords, may kindly permit me to show
So
one.
the only thing that he is wanting is that the mails be protected without deletion by respondent number 5. That is an innocuous prayer where it has to be preserved.
No, but now we'll have to summon him and get all these documents if that is the
ಅದು
case.
interim order ಇದೆಯಲ್ಲ?
Ade. And he's not, respondent number 5.
Lords, may kindly allow me to make a statement, my lords. We are not seeking any coercive action against any of the accused, my lords.
Correct.
Lords, may kindly protect the evidence, my lords. That should not be tampered with.
No, evidence protection is definitely an innocuous prayer which is necessary for investigation even in the crime. Tomorrow the interim order gets vacated and permission is granted to
No,
continue.
I leave it to your lords. If there's a direction,
My
we
lord,
will
the
summon him.
whole idea, my lord,
No, we can't stay.
If
but
Aదే
I
stay,
can't do
man,
that.
ಅದಕ್ಕೆ.
if I can, my lord, put it this way, see, my lord, what they are trying to do is, my lord, scuttle, my lord, the whole CIRP proceedings. 10,000
No, I'm
crores,
not,
my lord,
sir,
5,000 crores, my lord,
there are several other prayers sought with regard to CIRP. That I will not entertain at all, because ultimately that has to be before the NCLAT. Whatever decision of the committee of creditors, it will be only before the NCLAT. Now, what he says is the 5th respondent should not destroy the evidence. That is correct.
Malad, may I only point out one statement, my lords, that Mr. Baiju Ravindran is not the complainant in this so-called crime number 44 of 2025.
No, it is not in that. He's saying email should not be destroyed by the presently appointed resolution professional.
My lord, Mr. Baiju Ravindran is a fugitive, my lord. There's an ED lookout notice against him. There's a case for
Who is the
533
petitioner?
million.
Baiju Ravindran is the petitioner here?
Lords, he is a
He's not
suspended
the
director.
complainant in that said crime number 44.
No, he's not. Who is the complainant there?
The complainant was one investor, Mr. Rajendran Vellapalat, my lords.
Who is the complainant?
Rajendra, one Rajendra.
Rajendra. We investor in Baiju's.
in fact, he is, my lord, one person.
The GPA
Against, my
holder.
lord, again, my lord,
GPA
there are
holder.
Of Baiju's.
cases.
GPA holder and authorized, they've given him
No,
authorization.
GPA holder and authorized signatory of Baiju.
Lords,
Then not a stranger.
my lords,
He's not the
not
GPA and authorized
passing-
holder, my lords.
I'm not sure.
So that's what the.
No, the complainant is not the authorized signatory of Mr. Baiju Ravindran, my lords. I'm subject to correction.
That's what
Mr.
he's saying.
No, he's a GPA holder.
That's what the state is saying, sir.
My lord, there are proceedings against Mr. Rajendran himself in multiple proceedings in the US as well.
This is very unfortunate.
He's different. He's different.
No, I am. This
No,
is.
that's
my
what-
Can I request your
The whole
lordship
problem is,
tomorrow,
I'll tell
will
you.
produce, my lord?
First thing
Can I request,
is,
my lord, can
this
I
is
seek
a
one
holiday.
indulgence of your lordship?
You have moved the matter on a holiday because you moved the Honorable Chief Justice and he has directed us to sit. That's a different thing. Now, the others do not have the benefit of the copy or whatever it is.
Lords,
Now, the evidence protection part of it, definitely we can direct, and I'll post it on 21st. Let you serve on everybody. Let them file whatever they want to file. Hold on, sir, that should be fine.
My lord, if your lordships are saying no email should be destroyed or, my lord, tampered with, I have no problem, my lord.
That's all he is asking now. And insofar as COC proceedings is concerned, I am not going to interfere at all.
Lordship,
That I have made it clear.
Only thing is, my lord, the control should not go away, my lord, from, because what happens is
We are not
entire, my
No
lord,
control, sir.
You're
No,
not
no, I am only directing the resolution professional now appointed to hold
Correct.
the emails intact for the purpose
that's
of
all.
investigation
That's
in
all
a
right, my
future
lord.
date. That's all, sir.
My lord, can I ever say, my lord, no to that?
Is it
That's
Can I
what
ever say no?
exactly.
I'll never say no.
Lordship, is it possible to give a direction to the investigator?
But I'll tell your lordship,
Backup copy,
this is, my lord, a motivated
There's a-
complaint
see,
petition.
you
Yes,
must-
I
There's a
point out all
backup
that.
There's an
Let them
interim
serve a
order to
copy.
stay.
Milords, there's no stay against glass, Milords. In the investigation has to proceed against glass.
That you have to
With
seek
the
in that.
greatest respect,
No, no. If you are making anything against glass, then Holder sir will have to be heard.
I hold my.
That's all. Otherwise, I am not. Without hearing him, I am not passing any order. I'll post this on 22nd.
Can
I will now
No.
direct the fifth respondent to keep the mails intact because he is now the resolution professional.
please, my lord, please.
And
please.
COC things I am not going to entertain.
Then kindly
Correct.
grant me a
Please.
liberty, Milords.
What liberty?
Lordship, may kindly grant me liberty to amend the petition
For?
to withdraw the COC priors, so that Lordship may restrict it only to so that I can
No,
approach the
let him
appropriate-
withdraw the CO. Sir, he has sought for the stay of the COC proceedings on 8/4/2024/5, which I cannot, I will not entertain, I will not grant. That is, he says stay of all further execution of decisions taken in view of the minutes of COC. That I will not entertain.
No, Lordship may,
That is not-
either Lordship may dispose it with the direction, or Lordship may permit me to amend the writ petition.
We dispose with what?
The direction that the email shall be protected and
That, no, that if R5 has to be added in that.
oblige me.
Without hearing R5, I cannot. I will just now direct that he should not destroy or whatever prayer that you have sought.
No, please, please.
That only regarding the emails.
Lordship, is
Yes.
it possible to make it clear that as against the COC, I can approach the appropriate?
That's
take
always
appropriate
there. I'll
steps?
refer to a judgment of the Supreme Court only and permit you to do that.
Petition should not come in my way. They should not say that I've already approached your Lordship. That's
No, no, the writ petition is restricted to these prayers. I will also say that.
oblige me.
And the investigation, then you'll have to seek that prayer. No, against who's the accused there?
No, accused is,
Mr. Pankaj
Pankaj,
Srivastava.
Allah, crime number 44 of 2025.
ಹೌದು Pankaj Srivatsa,
Sir,
Dinakar,
what
Rahul
I
Agarwal,
must tell your lordship, see,
Gupta and Das.
Pankaj Srivatsava was, my lord, their person. He, my lord, this, my lord, on a particular, my lord, he initially put us all, my lord, in as members of the COC. One fine
That's
morning, by this, my lord, BS, he takes out everybody. He, my lord, he retains, my lord, only one person who holds, my lord, 1% of the entire, my lord, credit of the company.
Milords, it's admission on
No,
record.
all that fine, sir. Now he is restricting his prayer only to this email
Yes, my
thing. I will record that and give him liberty
Please, my
to
lord.
challenge the COC proceedings in accordance
Whatever,
with
my
law.
lord.
That's
That,
all.
my lord,
That
even
should not be
otherwise
a
he
problem.
has.
Yes. Who is the other counsel?
That's one.
You are appearing for him only, sir. 9.
Please, my lords, Mr. Holder is appearing for me.
Holder sir is appearing. Fine. Yes.
Please, my lords, one other submission, my lords, may be recorded what they had made, where they allege that the complainant is the GPA holder of Mr. Baiju Ravindran, my lords.
ನೀವು ಹೇಳಿದ್ದು
Your Lordship?
GPA holder of Baiju.
No, I have the authorization.
Well, it's a 482 petition is pending. They can agitate whatever they
That's
want.
what is there.
You made a statement, sir. I
No, no,
believe
I will verify that statement. Wait, sir.
Yes, please, my lords, because that will be very
What do
critical.
you-
Milords, is it possible to call for the case records on the case diary for the next occasion, Milords?
That will see. Next. Wait. He has it. Yes. No, this prayer is innocuous because for any time investigation documents are necessary. That is not a problem. Nobody will object to that. But others, all others, I am not granting.
Oblige.
You have not served on everybody.
Milords, actually, we got a call also today morning. I apologize.
Where are you from?
I'm from Delhi, Milords. I'll ensure service before the next day.
No.
On the next date, I'll produce that.
Gets
So-
a call in the morning and comes, my lord, here.
It is on their instructions.
They don't serve a
then-
copy of that.
See, that's a clinching point. If that is there, then it will be a
No,
problem.
I'll clarify that on the next.
If the complainant is
No, no, I'll
Baiju's
clarify,
authorized
I'll clarify.
representative,
No, Your Lordship, I'll clarify that on the next.
then tables get turned.
It is only on their
Our
instruction.
instruction. No, that was, I think, on the instructions of the investigating
office-
officer. Yaru? Ian ಮತ್ತೆ instruction ನಿಮ್ದು?
Please, my lords,
Yeah,
even
no,
the
no,
counsel,
So he
even the
says that
counsel,
the
my lords, from Mr. Baiju Ravindran had made a statement that the complainant is his GPA holder, my lords.
He had made, is it?
He just made it, my lords. Let him clarify
No,
that.
he
as
made it, but that's not in the
well.
record.
Not the state, my lords. The counsel for the petitioner. that is Mr.
Council also said, state also said.
Please,
You
so
said
the counsel.
complainant is Byju's GPA
I
holder.
have approached
That may be recorded, my
solely-
lord. The petitioner
I have
counsel's
approached the
submission may be
lord
recorded.
solely
No,
as
no,
the
because my
funding
lord, that is
director,
it is a totally motivated complaint. There is proceedings pending in the US courts. $533 million,
It's a
my lord, has
cognizable
been
offense.
totally
I'm not
taken
sure
up
why
No, that's all right. Yes.
through the
It's a
conduit
cognizable
of
No,
this
all
particular
that,
complaint.
see.
they want to run away from.
No. All that 482 proceedings are pending. You can seek the prayer there.
Very well, my lords, but
All
the
right.
statement was made in
So
court today, my
this
lords.
I will just record. So we proceed to order. Order, sir.
Please,
I'll
my lord.
pass that order with regard to
Please, my lord.
the maintenance of the mails by the fifth respondent. Please, yes.
I don't want any allegation that, my lord, he was trying to destroy and all that.
No, that I will not. I will just say this is necessary
Yes,
for
my lord.
investigation at any point in time.
Grateful to you. Grateful to you.
Yes. No, you said investigation should be permitted against someone. No, that I will not. That is only before the 482 court.
I'll just express one concern, my lords. I'll leave it to your lordship after that. My lords, in the COC meetings, he says that more than 2,900 emails have been deleted.
Correct.
The difficulty is, my lords, all these service providers, MSN, Google, Gmail, and all these persons, my lords, I believe the maximum period for which they retain a data is for 25 to 30 days, my lords. Now, if the matter goes on in this manner, my lords, we will be in a position where we won't
I will direct.
we won't be able to recover the data.
Preservation of data, I will direct.
Lords.
Nobody can object to that because it would be undoubtedly necessary for investigation tomorrow if the interim order gets vacated or otherwise.
Obliged.
Yes. What's your name?
Shyam Mohan, my lords.
Right.
Shyam.
Shyam Mohan.
Yes.
The petitioner, one Baiju Ravindran, is at the doors of this court seeking several prayers. The first prayer is to direct the first respondent to freeze the corporate insolvency resolution process and preserve the loss of emails or data in view of the minutes of the COC meeting held on 8/4/2025. The second prayer is to direct or initiate necessary process in law to recover and restore all data deleted from the email that he has mentioned in the prayer and to preserve the same for continuance of fair, proper and complete investigation in crime number 44 of 2025 pending registered before the High Grounds Police Station. The third prayer is to produce the case diary of the investigation conducted till date in crime number 44 of 2025. The fourth prayer is to expedite the investigation in crime number 44 of 2025. The fifth and whatever. In furtherance of the aforequoted prayers, interim orders are sought. The learned counsel, Shyam Mohan, appearing for the petitioner, would take this court through the documents appended to the petition, seeking to demonstrate that the earlier resolution professional has admitted certain things in his affidavit before the IBBI. And the fifth respondent is now appointed as the resolution professional. In the light of the COC meeting that was held on 8/4/2025, the learned counsel would submit that the emails that would be required for future investigation in the matter should not be destroyed, as the proceedings would refer to the statement of the fifth respondent that about where did you say that 2000 something
IBBI, my lords.
page 2000 mails holders.
Page 63, my lords.
Madam, sorry.
Page 63 is a COC, my lords.
The statement of the fifth respondent that 2,392 mails were deleted from the process due to refoldering of the mails. The learned counsel would submit that
Please, my
the
lord, this was a statement made by the erstwhile IRP, my lords. That may also-
erstwhile RP, correct. By a statement by the erstwhile RP, that Pankaj someone.
He's
Yes.
accused number 1 minute.
Erstwhile, by the erstwhile RP name also, Pankaj Srivatsava. The learned counsel would submit that if emails are deleted, they are the primary evidence of the conversation or interaction between the companies with regard to the subject matter that is pending before the NCLT. He would submit that those mails should not be permitted to be deleted, and those are necessary for the purpose of investigation. The learned counsel would submit that now the fifth respondent has been appointed as a resolution professional. Therefore, he should be directed to preserve those emails. The learned AGA, Rahul Karyappa, appearing for the state, would on instruction submit that the investigation in crime number 44, rather, 44 of 2025 has been stayed at the hands of the coordinate bench in criminal petition 3717 of 2025. At the hands of the coordinate bench on in 3717 of 2025 in terms of an order passed on 17/3/2025.
Lordship, it's only Quay, the petitioner there, and 2 other.
No, whatever it is, Quay the accused therein. Therefore, the state has not proceeded to continue the investigation in the light of the interim order so granted, so granted. In that light, the other prayers that are sought by the petitioner with regard to expediting investigation in crime number 44 of 2025 or the crime number 44 of 2025 or production of case diary in crime number 44 of 2025, if considered, would run counter to the interim order granted by the coordinate bench directing stay of further investigation, as the interim order granted therein is as prayed for. The learned AGA would further submit that if this court would permit the material that the learned counsel is presently submitting could be taken, could be seized.
Allah, seized Allah. No, since there is a stay, we cannot do anything.
Nothing, you can't do it.
Better buddy.
The learned then, but a statement, but the learned senior counsel Shri Uday Holla, appearing for the petition, appearing for the ninth respondent, ninth respondent would submit that any other prayer other than what the petitioner is now restricting to, if granted, he would, if considered to be granted even as an interim measure, he would require time to file his statement of objections. But insofar as the preservation of the mails by the resolution professional, the fifth respondent, the ninth respondent to whom the learned senior counsel is representing would have no objection, as it is a material that would be required for investigation at any point in time. In that
or
light,
even, my lord, for the CIRP itself, my lord, even for the CIRP, it is needed.
Even to the CIRP investigation
Yes.
at any point in time, and even to the corporate insolvency resolution process, the CIRP. Therefore, the prayers that would merit consideration at the hands of this court at this juncture would only be with regard to prayer 1 and 2, which directs preservation of the mails without any further loss of data, and the direction, and the first respondent state, and
first
the
respondent.
other, you have to seek their recover in the only two Allah. Only prayer that merits consideration at this juncture is to preserve the conversations, the mails from IP there on the addresses, IP addresses, other mails to be preserved. The learned counsel would further contend that he be reserved liberty to agitate the minutes of the Committee of Creditors held on 8/4/2025 before the appropriate fora. The submission would merit acceptance in the light of the judgment of the Apex Court in the case of so and so 2025 SEC Online SC page 23, para 9 and 10, where the Apex Court holds that the IBC is a complete code by itself, and the complete code by itself with adequate appellate remedy available for the petitioner to call in, for the aggrieved to call in question before the National Company Law Appellate Tribunal. Therefore, those proceedings which the petitioners has sought to challenge, i.e. the minutes of the COC meeting or otherwise, has to be agitated only before the NCLAT. It is open for the petitioner to avail of that remedy. The remedy of filing a writ petition, calling in question those proceedings is unavailable in the light of the judgment of the Apex Court.
NCLT or NCLAT?
National Company Law Tribunal or the National Company Law Appellate Tribunal, as the case would be. In the light of therefore, all those prayers that challenge the minutes of the COC in the be it interim or final stand rejected. The only prayer that is only prayer that can be granted at this juncture is directing the fifth respondent to preserve all the emails or conversations between the party, between all the stakeholders in the case at hand, in the case at hand, which would be required, even required for CIRP or investigation, as the case would be. Should I keep it or dispose it? But fifth respondent may have to be heard.
21st.
List on 21st at we'll take it on 22nd. 21st we'll have 500.
But 22nd, 22nd I have some problem. I'm in Supreme Court. Can it be either on 21st or 23rd? Subject to your lordship's
21st hakirtini. After all the matters are over, we'll take it.
Yes.
Please.
One
We'll
more
close it on that day
aspect.
after hearing.
Very well. Malad, can I?
Yes, sir. Yes, sir.
Can I?
Yes,
Malad,
sir.
your lordship may not say that, Malad, I have admitted that it is needed for investigation, because according to me, Malad,
that
complete.
I will. That's all. It is undoubtedly needed, sir. I will say. I will not say that you have admitted.
First ಹೇಳ್ಬೇಕಾದ್ರೆ I admitted ಅಂತ ಬೇಡ ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲಿ ಹೊಳ್ಳ ಸರ್ದು.
Please, Malad, that's all, because I don't want the parties to.
Has no objection for such a prayer ಅಂತ ಹೇಳ್ಬೋದಲ್ಲ? ಅದು ಬೇಡ.
For preservation of Malad, not that for it is needed for investigation or anything. That's all, Malad, that I would say.
That's all. That I'll correct it, sir. I'll correct it.
Please, my lord, just the other point, my lords, on the locus of the petitioner himself being in doubt, because if he says that the complainant is his authorized representative, and if he now is backtracking from that statement,
then you can challenge, you can submit all that in 482.
But the petitioner has filed the petition here in this crime number 44.
Glass.
Senior had appeared for
He is
9.
also appearing for glass.
2 people can appear.
No, if that is, then please let them clarify who is authorized.
You have woken up from a holiday, so sab chal. Huh?
Notice.
No, that's all right. That's okay. Strict rules, if you begin to implement, then no junior will come up. Yes. All right. See, that is before 482 court, whatever you want to tell. I have not granted any other prayer. It's only, we'll keep it on 21st.
Let him serve the copy.
I undertake
The learned counsel for the petitioner shall serve requisite set of petition papers on all the respondents and file an acknowledgement of such service before this court. Yes, list on 21st. So no submission about COC in future. Yes. Unmute Madi, sir.
Sorry, no. Even on a holiday, we don't leave you. We don't permit you to relax even on a holiday. That's all I can say.
Yes, sir.
It's only your kindness and goodness and grace that your lordships are still smiling and coming.
Absolutely, sir.
Much obliged.
Grateful.
ಹೇಳಿ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಎಲ್ಲರೂ ಎಬ್ಸಿ
ನೀನ್ ಮಲಗಿದ್ಯಾ?
ಮಲಗಿದ್ದವ್ರನ್ನ ಎಬ್ಸಿ ನಾನು ಬೆಳಿಗ್ಗೆ
ನೀನ್ ಮಲಗಿದ್ಯಾ?
ಬಂದಿದ ತಕ್ಷಣ ಕೇಳಿದೆ, ನಿದ್ದೆ ಮಾಡಿದ್ದೆ ಕಬಡ್ಡಿ
Thank you. Sorry for the.
No, no, no.